And thank you for this opportunity to speak on behalf of my people, the Sac and Fox Nation, and what this means to bring Jim Thorpe home. I was raised traditionally, as most of our people are, and whenever our people move off for whatever to another state, somewhere else, they always come home, either while they're living or their families bring them home after they expire. And this is what our people want with Jim Thorpe. This is his family's wish. This is his own personal wish, was to come home to Oklahoma, Sac and Fox country, to be buried. A lot of tribes are watching this case nationally because this outcome is going to affect their people, their burials, their repatriations. So I thank you for this opportunity to share what it means to our people, the Sac and Fox Nation. Thank you.
I'm Steve Ward, and I have the honor of being counsel to the Sac and Fox Nation. And I'd also like to introduce my colleague, Richard Guest, an appellate attorney with the Native American Rights Fund. And I'll just say, you'll meet John Echo Hawk here in a few minutes. I'd like to just say thank you to both of these men and to the Native American Rights Fund, which is an invaluable advocate for the rights of Indian people and tribes in the United States. We're here today at the culmination of a very long road that didn't start with this filing of this lawsuit in 2010. This started in 1953. The sons of Jim Thorpe, Jim Thorpe's family, objected to the removal of his body from the Sac and Fox ceremony to a town in Pennsylvania. They objected many times over the years, but they didn't have any legal tools until the passage of an important statute in 1990. That statute is the Native American Graves Protection and Repatriation Act. This case, as Chief Thurman said, is a very important case in Indian country. Involves some very important issues to Indian people and the tribes. Richard and I would like to just briefly survey a couple of those, and they're discussed in more detail in the petition for cert. One is whether whether the plain meaning of statutes will be enforced by the courts. For many years, the United States Supreme Court has required courts to follow the plain language meaning, the meaning that can be gleaned from the texts, the plain text of statutes as reflecting what Congress intended. And in this case, the United States Court of Appeals for the Third Circuit invoked a doctrine, a judge-made doctrine, that has not been recognized for many years by the Supreme Court, to essentially apply the judge's subjective interpretation of Congress's intent. This case also raises, for that reason, separation of powers issues. In other words, the meaning of statutes is supposed to be gleaned from the language Congress enacts and not from judicial interpretations. So, Richard, if you'd like to add to any of this, this case does present some very important questions, particularly for Native American people and tribes, but also in general, in the general context concerning the interpretation of statutes.
Thank you, Stephen. I didn't anticipate standing here today, but what I'd like to add is through the Native American Rights Fund, we jointly coordinate the work of the Supreme Court project with the National Congress of American Indians, and the appellate litigation involving Indian people and Indian tribes moving up to the U.S. Supreme Court is a part of our docket. And so we've been involved with this case even before it was at the Third Circuit. And now that the cert petition has been filed with the U.S. Supreme Court yesterday, we're moving our attention to the amicus briefs in support of that cert petition. At the Third Circuit, The National Congress of American Indians filed an amicus brief. Senator Ben Nighthorse Campbell, the author, original sponsor of the Native American Graves Protection and Repatriation Act, filed an amicus brief, basically telling the Third Circuit that this is exactly why, this case is exactly why Congress passed NAGPRA. At the Supreme Court level, we're looking to expand that amicus support in addition to the NCAI and tribal amicus brief, in addition to a members of Congress, including Ben Nighthorse Campbell, amicus brief. We're also looking to religious organizations. And we have a very experienced Supreme Court practitioner taking the lead, representing religious organizations and expressing the views of mainstream organizations involving the religious issues in this case, and the need for statutes like NAGPRA, RFRA, the Religious Freedoms Restoration Act, and RLUIPA, applying to the states, the religious freedoms. That this really is about the ability of the tribes to complete the burial ceremony, so wonderfully demonstrated in the play by the actors today. Lastly, we will have, are looking at a law professor's brief to really focus in and have the court. Oddly enough, it is the conservative justices on the court who look to the question of the role of the courts in interpreting statutes. And you will hear from Justice Scalia, Congress meant what Congress said. Stick with the plain language of the statute. And in this case, the Third Circuit acknowledged that the plain language of the statute would apply to the borough and the remains of Jim Thorpe, but said that cannot be the result in this case. It would be absurd to think that Congress intended this to apply, and substituted their own values, their own judgment for that of Congress and for that of Native American tribes across the country. Thank you.
Well, thank you. Thank you, Richard. And just to add one brief comment, the road to achieving civil rights for American Indians has been a very long road in this country. For one thing, there are relatively few Indian people, and this has been a difficult and long road. And Chief Thurman, John Echo Hawk, the Native American Rights Fund, who stand here in front of you, have been leaders in that effort over the years. This statute is very important to Indian people, and we face now a judicially created exemption to a very important statute, and also an exemption created by a United States Court of Appeals in a circuit that has no federally recognized Indian tribes. Of the more than 500 Indian nations in the United States, none are located in the Third Circuit. But yet, this is a decision that really cries out for review by the Supreme Court because of its importance and because one circuit's decision could very well have the possibility of undoing a very significant achievement by NARF and tribes and others through the enactment of the statute in 1990. I would like to next introduce Sandra Massey, who is the Historic Preservation Director for the Second Fox Nation. She may be someone that you'd like to ask some questions of after we finish. Sandra is a repository of a lot of information about Second Fox Nation history and culture. And I think Sandra would like to talk a little bit more about the importance of this case.
Well, I just have to say that I am very angry. We enacted the Native American Graves Protection and Repatriation Act because for years we were disregarded. Our graves were looted. The Army took, they had a quota they had to meet by taking us from the battlefields and from our graves, and they treated us as relics and not people. And that's still going on. 25 years after NAGPRA, we're still fighting for the right for a man to decide for himself how he wants to be buried. And he wanted to be buried according to our way, our Sac and Fox way. This is the way that I'm going to be buried. And we were getting all kinds of, well, did he write this down? No, we don't write it down because we've had things taken out of context. We don't do that. And then he had the right to decide what he wanted to do. He didn't want to be sold, and that's basically what happened. He did not want to be sold. He needs to come home. So I'm angry about this. I'm angry that we have a tribal member, and we're having to fight for the right for his own sons to bring him and give him the burial that he wanted. So I'm angry about that. I'm angry because 25 years later, no one's still listening. They were still not being listened to. 25 years later, and that's a quarter of a century, and we're still here fighting for a NAGPRA cause, and we're still fighting for our religion to be as taken seriously as anybody else's. So I understand why he wanted to be buried the way he's wanted to be buried, because I'm going to be buried the same way. It's a part of our identity. It's a core part of who we are as Sauk people. And I'm sure there are other tribes that feel the same way about theirs. There are certain things that we bring to these, certain things that we do. There are reasons why we do this, and yet we're having to sort of explain why we want this to happen, why we want to do this for this man in a court, because this is an arena, a playing field for somebody else's thought, not ours. We're having to make our thoughts fit into this arena. Why do we have to justify ourselves when we are a nation here in America with a government-to-government relationship with the United States? So I am angry. I'm very angry because we're having to do this, because we're having to try to make people understand why we're here and why we're doing this. And I grew up with people hearing Jim Thorpe called Dad. He was dad to a lot of people. He wasn't the great Olympian to Jack or to Bill or to Grace or to Gail or anybody that I knew. It was Dad. I grew up hearing him called Dad. So I knew his family, and that's just it. We're fighting for this family. And that's what we do in NAGPRA. We fight for our family. Whether or not we really even knew who they were, they are all a part of who we are today. Their bloodline is in our veins right now, and that's what we're bringing into this. And I've got a niece. I'm going to be passing that on to her. So we have to hold on when, that's why I'm angry too. I'm having to hold on instead of just teaching her. We have to fight. We have to fight and say why we want to do this, why this is right. So, yeah, Jim Thorpe needs to come home. Thank you.
The Native American Rights Fund is the National Indian Legal Defense Fund, and we've been around 45 years providing legal advice and assistance to our Native people around the country in cases of national significance. And a lot of our people need help because they can't really afford lawyers, so that's put us in the middle of a lot of the most important legal issues facing our people. Early on, beginning in the 1970s, we started working on cases for Native people where they complained that their ancestors and their ancestors' burial goods had been taken away and put into museums without their consent, without their permission, and this was a widespread issue everywhere. And finally, we got so many cases going that we were winning, and the courts and the legislatures around the country siding with us and saying, this is wrong, we need to fix this. Indian people have the right to control the graves and burial sites of their people just like everyone else in America. And that's when we got help from people like Senator Ben Icehorse Campbell to get passed in Congress the Native American Graves Protection and Repatriation Act. And we've been involved in implementing that ever since then. This case that we're talking about here today involving Jim Thorpe is one of those important cases about implementation of the Native American Graves Protection and Repatriation Act. Because if they're able to create an exception for the application of NAGPRA to situations like this, then we're going to lose a big part of the intent of that law, and it's going to basically undo what a lot of us have worked on for many, many years, the law that has benefited many of our tribes and Native people around the country as we've been able to repatriate these remains. So this is a big issue for Indian country, and we're pleased to stand with the Sac and Fox Nation and the Thorpe family in trying to enforce NAGPRA. Thank you.